हेलो एवरीवन, नमस्कार। आप सब कैसे हैं? उम्मीद करता हूँ ये जो हमारा 7 डेज का सर्टिफिकेट कोर्स है, तो आप सब इसे एंजॉय कर रहे होंगे, आपकी लर्निंग बढ़ रही होगी। बिकॉज एवरी डे वी हैव ट्राइड टू एड अप समथिंग न्यू न्यू इन द नॉलेज, न्यू इन द एक्सपीरियंस, न्यू इन द challenges as well. As today we are here on the 6th day, and we are going to discuss the legal aspects and agreement, because for every startups legal aspects are very important, agreements are very important. अगर आप शेयर होल्डर्स के एग्रीमेंट या प्रमोटर्स का एग्रीमेंट, फाउंडर्स का एग्रीमेंट की बात करें या इवन वेंडर्स के एग्रीमेंट्स की बात करें, तो बहुत ही ज्यादा जरूरी होता है किस एग्रीमेंट में किस तरह के क्लॉजेस हमें डलने चाहिए, सो दैट अगर कभी कोई प्रॉब्लम हो या कोई इश्यू हो तो उसे किस तरीके से रिजॉल्व किया जा सकता है, क्या आर्बिट्रेशन का भी कोई मैटर आना चाहिए। सो कंसिडरिंग ऑल दिस, द लीगल एस्पेक्ट्स आर वेरी वेरी इंपॉर्टेंट। और जैसा कि हम लॉ की अगर बात करें तो हमें एडवोकेट और प्रैक्टिसिंग एडवोकेट की हम बात करेंगे, और उन्हीं के साथ आज बहुत ही एक्सपीरियंस्ड स्टार्टअप के फील्ड में, ड्राफ्टिंग के फील्ड में हमारे साथ आज के इमिनेंट स्पीकर हैं एडवोकेट पुलकित गोयल जी। पुलकित जी, हार्दिक स्वागत है आपका। और पुलकित जी के बारे में अगर मैं बताऊं तो आप पंजाब एंड हरियाणा हाई कोर्ट के बार एसोसिएशन के मेंबर हैं। ही इज आल्सो मेंबर ऑफ एनसीएलटी बार एसोसिएशन चंडीगढ़, and he is also member of Debt Recovery Tribunal Chandigarh Bar Association. Along with that, he is also the member of District Court Bar Association Batinda. तो अगर मैं पूरा प्रोफाइल देखूंगा तो पुलकित जी का बहुत बड़ा एक्सपीरियंस है, बहुत लंबी प्रोफाइल है। सो विदाउट गोइंग इनटू दैट, डायरेक्टली आई विल रिक्वेस्ट पुलकित जी टू टेक दिस सेशन फॉरवर्ड, और हमारे जो ऑडियंस है उनको आप एड्रेस करें, आज लीगल एस्पेक्ट्स के बारे में डिटेल में चर्चा करें। ओवर टू यू पुलकित जी।
नमस्कार Anuruddh ji, and hello to everyone else as well. Thank you. It is my pleasure to be here. तो आज हम लीगल एस्पेक्ट्स के ऊपर, जैसे आप लोगों ने दिया है कि लीगल एस्पेक्ट्स फॉर स्टार्टअप्स, विल बी गोइंग ऑन टू दैट। तो उससे पहले सबसे पहले फॉर्मेशन के ऊपर आता है। तो फॉर्मेशन का आप और कवर कर चुके हैं ऑलरेडी, आई बिलीव मिस्टर तिवारी जी, वो आपका जो हो गया था सेशन पहले। तो फॉर्मेशन में फर्स्ट ऑफ ऑल देयर आर वेरियस थिंग्स के व्हाट टाइप ऑफ अ फर्म और व्हाट टाइप ऑफ अ कॉर्पोरेशन डू यू वांट टू बिल्ड, पार्टनरशिप, एलएलपी, कंपनी, sole proprietorship. These are amongst the various incorporation types which can be incorporated for a new business. तो वो टॉपिक हम कवर कर चुके, तो उसमें मैं नहीं आऊंगा। मैं उससे आगे चलूंगा थोड़ा सा कि जब हम फॉर्मेशन करते हैं कोई भी एक कंपनी, पार्टनरशिप, सोल प्रोप्राइटरशिप, एनीथिंग। सोल प्रोप्राइटर तो एक, चलो एक वन सिंगल पर्सन हेड्स इट आउट, पर जब हम पार्टनरशिप की बात करें तो उसमें ज्यादा जने इन्वॉल्व होते हैं, एक से ज्यादा, दो या उससे ज्यादा जने इन्वॉल्व होते हैं। एलएलपी इज अ फॉर्म ऑफ कंपनी एंड पार्टनरशिप। तो कंपनी के बारे में बात करते हैं। पहले कंपनी दो टाइप्स की होती है, प्राइवेट लिमिटेड, पब्लिक, प्राइवेट और पब्लिक कंपनी। फिर आता है लिमिटेड और अनलिमिटेड। लिमिटेड इज बाई लिमिटेड नंबर ऑफ इट्स शेयर, अनलिमिटेड इज अनलिमिटेड नंबर ऑफ शेयर, जहाँ पे लाइबिलिटी टुवर्ड्स द शेयर होती है और जहाँ पे आउटसाइड द शेयर भी होती है। और कंपनी होती है पब्लिक एंड प्राइवेट, एज वी टोल्ड। फिर आती है एलएलपी। एलएलपी है पार्टनरशिप और कंपनी का एक फॉर्मेशन, एक बीच का, जिसमें पार्टनरशिप फर्म की सारे उसमें वो है कैरेक्टरिस्टिक्स, एंड इट हैज अ कैरेक्टरिस्टिक्स ऑफ योर कंपनी। सो व्हाट हैपेंस इन एन एलएलपी इज इट इज अ पार्टनरशिप फर्म विद लिमिटेड लाइबिलिटी। जो उसके पार्टनर्स हैं उनकी लाइबिलिटी सिर्फ और सिर्फ उनके शेयर होल्डिंग या कंट्रीब्यूशन तक रहती है, जबकि एक पार्टनरशिप फर्म में, नॉर्मल पार्टनरशिप फर्म में, उनकी कंट्रीब्यूशन अनलिमिटेड होती है टू द एक्सटेंट दे आर पार्टनर्स एंड देयर आफ्टर एज वेल। पर एक एलएलपी में सिर्फ और सिर्फ उसकी लिमिटेड एस्पेक्ट के लिए रहती है जितनी उनकी कंट्रीब्यूशन होती है। सेम ही कंपनी का होता है। कंपनी में भी दो टाइप, लिमिटेड होती है जहाँ पे वहां पे उनकी लाइबिलिटी टुवर्ड्स द शेयर होल्डिंग रहती है, और जहाँ पे अनलिमिटेड हो जाती है वहां पे उनकी जो लाइबिलिटी रहती है दैट गोज अनलिमिटेड। अब सबसे पहले, जैसे आप लोगों ने मुझे दिया हुआ है कि फाउंडेशन अग्रीमेंट या शेयर होल्डर्स अग्रीमेंट, तो उसके ऊपर स्टार्ट करेंगे। तो सबसे पहले हम स्टार्ट करेंगे ऑन व्हाट इज योर फाउंडर्स अग्रीमेंट। फाउंडर्स अग्रीमेंट क्या है? फाउंडर्स एग्रीमेंट बेसिकली एक अग्रीमेंट है जिसमें हम सारे, एट द टाइम ऑफ फॉर्मेशन ऑफ ए कंपनी, ऑल द थिंग्स आर पुट इनटू इट कि व्हाट एंड ऑल गोज इनटू अ फाउंडर्स अग्रीमेंट। लेट मी जस्ट yes. तो फाउंडर्स अग्रीमेंट या फाउंडेशन अग्रीमेंट, जब भी हम कोई नई कंपनी, पार्टनरशिप फर्म या एलएलपी फॉर्म करते हैं, इट इज ऑलवेज नेसेसरी कि हम हमारे टर्म्स सेट फॉरवर्ड कर दें। एक फाउंडेशन अग्रीमेंट में it is necessary we put forward all the terms of the characteristics of a business, name of partners, the characteristics and job profiles of the people, employees, everything. Basically, in and out comes out your foundation founders agreement, as we can say. In founders agreement, moreover, we have to keep sure that what type of firm or company are we building. उसमें हमेशा हम जरूर लिखेंगे सबसे पहले कि हमारा रोल क्या रहेगा एक फाउंडर का कंपनी में। फाउंडेशन, जस्ट 1 मिनट प्लीज। आई एम सॉरी, यस। यस, यस। तो फाउंडर्स एग्रीमेंट इज वेरी इंपॉर्टेंट फॉर अ फर्म। उसमें हम सब कुछ सेट फॉरवर्ड करते हैं। जैसे कंपनी है, कंपनी के फाउंडेशन अग्रीमेंट्स में क्या कुछ आ जाता है, इट इंक्लूड्स योर एमओए, एओए, आर्टिकल्स ऑफ एसोसिएशन। देन योर एओए कंटेन्स ऑल द थिंग्स which are required for associations functioning. Then there is MOA, that is memorandum of association, how a company is formed, what and all will be incorporated in that. For a partnership firm, it can be your partnership agreement, the basic partnership agreement, in which it provides who and all will be the partners, what is the necessary and what is the line of work the partnership firm or the firm is going to do. One is that. The other is, as I already told, their contribution. One second would be their roles, as to what work will they do, what assignment will they be handling, and other aspects in that. And why are these agreements necessary? I'll start with that. Foundation agreement is necessary for a startup. It is one of the most basic agreement. In foundation agreement, you have all the crux of a company, what it is going to be, how it is going to go forward. So until a foundation agreement, tomorrow, supposedly a company is running and we have not set forward the job work of a company, the profile of the partners or the directors of the company, the profile of the members of the company, what are they going to do? Disputes are created in that. As we have majorly seen in legal aspects, what happens is whenever major disputes which happen, even in companies act, I'll start for companies, oppression and mismanagement comes up. Why does it happen? Because at times we have not set out the scope of the roles of an individual in a company. Supposedly one person goes outside its purview. Going into that, what he does is he does certain works which are not supposed to be done by him. He goes on to transfer shares. I'll be coming to shareholders agreement as well later on, but he goes on transferring the shares. He goes on taking up business assignments or providing services which are not within the purview of the company or within the purview of our foundation of the formation. That leads to various illegalities, various legal complexities, which tomorrow leads to a company being pulled into various litigations for no fault of its own. That is one of the reasons. And foundation agreement provides it provides you all with a stable ground, so that tomorrow any dispute is arrived, so it can provide us a ground to show that what and all is that. These agreements are as necessary when everything is written. There is nothing you can go out of that. So that is about the foundation agreement. Next, we'll come up to shareholders agreement. So what is a shareholders agreement? Once a shareholder agreement, basically I'll say for startups, when it is ready and it has to be moved ahead, put forward into an industry, we as a firm, a unit in that industry, come out, there will be many investors who will want to invest in a company. They can be private as well, it can be government entity as well, it can be any person as well. So whenever someone wants to invest in a company, it is necessary it is always put on in writing. That is a shareholders agreement as to what is their investment going to be, what is their investment going to be towards, and how much is it going to be limited towards. So a shareholders agreement basically provides us the crucial, it is one of the most crucial startup document. It helps us to determine the rights and liabilities of the shareholders as well. As to when a shareholder invests in a company, he would be very much aware of what is his right in the company. Tomorrow, a company is to do anything, any business, any line of action, any service providing, or anything at all. Company is formed, run through directors. But however, a shareholder is also would only want to invest if he knows what right he has, how much of control he has over the company, what are his voting shares, what would be his voting right in the company, when and how can he vote, whether if there's any issue going on in the company, how and when can he interfere and try to stop it or go through it. And it is also necessary that his role is also put up for the benefit of the company, as if a shareholder's role is not limited or given a limited holding in the shareholders agreement, he can try to incorporate, he can try to he he can try to run into the affairs of the company, or he might try to bulge into the affairs of the company, which might also create hindrances for the company's running. So it is very necessary that we always in a shareholders agreement define the role of the shareholders. That is one. And apart from that, we also provide what and all they're contributing towards the company and how much is their liability going to be. Supposedly that, for example, if they're contributing 100 rupees into the company, they should be aware that their liability toward that will only be 100 rupees, or it is going to be more than that. Is it mandatory to sign shareholders agreement? Yes, of course. When a shareholders agreement is done, it is mandatory to be signed between the shareholders and all the investors, because until and unless you don't have anything in writing, you do, when it is in writing and it is unsigned, you do not have it as a legal proof to hold it against someone. The shareholder cannot hold it against you and the company cannot hold it against us. तो बहुत जरूरी है कि एक शेयर और कंपनी के बीच में जो इन्वेस्टर्स का अग्रीमेंट रहे वो जरूरी है साइन होना. कोई भी agreement, leave it for, not only shareholders, any agreement per se is necessary to be signed. For a foundation agreement, supposedly it has to be signed by the directors in the company, the MOA, AOA. For a partnership firm, it has to be signed by the partners. Similarly, for LLP, it has to be signed by the partners. So it is always necessary that each and every document is signed. Tomorrow, without a signature, it cannot be held legally valid, as it is in writing. But until and unless someone doesn't do it, sign it, it doesn't become official. And moreover, it is always necessary that any agreement, let it be founders agreement or shareholders agreement, it is done in white and black, that is in written itself. Because oral agreements usually end up creating a dispute. Oral agreements, especially in startups, when there is nothing in written, you cannot hold anything against someone. So sign and writing is necessary. So yes, where was I? In shareholders agreement, it is necessary put in the roles, as I said, and of course the liability. How much is the liability going to be? Is it going to be limited? Is it going to be unlimited? In a partnership firm, as I have already stated in the starting itself, partnership firm, what happens is the liability of the partners is unlimited. Tomorrow, supposedly, the partnership firm owns anything to any third party. So the partners can have to contribute out of their personal liabilities. But however, in an LLP, it is always given that it is, as in the name it is suggesting, limited liability partnership. Their liability is limited to the contribution of shareholding they do in the LLP, as in case of a company. So it is necessary that the liability, as in the role and the limited liability aspect of shareholders, also be done in that. Then also comes your rights, duties, and responsibilities of the shareholders. Not only the rights, but duties also are necessary. What duties does the shareholder have of the company? It is necessary that also be incorporated in shareholders agreement. Apart from that, whenever for a company shares are issued, it is necessary you put in the procedure for issuing new shares, for transfer of shares, and supposedly a new, or the company wants to buy back the shares from the open market. All those conditions are also necessary to be put in a shareholders agreement, so that tomorrow there is no difficulty which comes up when and so any legal compliance towards the shareholding is to be done. Moreover, there are different type of shareholders. Some can be minority shareholders, some can be majority shareholders. So it is necessary we set out the roles and the liabilities of them as well individually. Minority shareholders should also be looked after, and protection, what can be done by the company, is also necessary to be put forward in that. Apart from that, a shareholder or anyone wants to invest in a company knowing that of course they'll get something in return. So it is necessary we put in what is going to be the dividend or what is going to be the revenue they get from our incorporation. It is necessary to put in the amount or the dividend they might receive from a company. That was a question also. I'll answer that question. Will the liabilities be governed by shareholders agreement or companies act? The liabilities are governed by the Companies Act as well as the shareholders agreement. When you have put in something, the shareholders agreement also, any clause in an agreement cannot be void ab initio or cannot be out illegal, as they say. So whenever an agreement is formed, it provides for all the things which are only legally binding, and it has to be as per the Companies Act. Anything which is illegal or outside the purview of Companies Act is not a part of shareholders agreement, and that makes that clause itself ab initio, void ab initio, as in wrong from the very beginning. So apart from that, when a startup is formed, the various other agreements apart from founders agreement and shareholders agreement, there are other agreements as well. There is an investment agreement that is almost similar to the shareholders agreement. What happens is it is a contract between the company and investors who want to purchase the shares of the company. In that way, the investor can be a new shareholder or an external investor. Even the existing shareholder can become an investor, wherein he invests towards a certain project or towards a certain services only, not for the whole company, but towards a certain period of time or for rendering certain services only. So that's an investment agreement that is as well very necessary. Apart from that, startups usually are formed keeping in view basic ideas. Ideas come up, and that's when you form a company or you form a partnership firm and try to get a business going or any enterprise going. Whenever an idea such as come, of course we go towards certain people, investors, shareholders who want to invest in our idea. And in that case, it is very necessary that a startup at the start has a known non-disclosure agreement. As in, whenever we go to an investor taking an idea, okay, sir, this is our idea, we want you to invest in it tomorrow, so that no one takes our idea and uses it in its own, puts up his name and tries to circulate that idea going. So it is necessary a non-disclosure agreement is put forward, and also it is necessary that he doesn't circulate that idea to people. So non-disclosure agreement is really, really necessary for a startup tomorrow to protect its rights and to protect its major business. Because without the idea or without the line of functioning, of course, any startup will go down from where it started. So non-disclosure agreement is very, very necessary. Apart from that, you have your employment agreements. Now, of course, whenever a company starts or any enterprise starts, you need people working in it. Not only the shareholders or directors, but there are people in the founders, but there are people who will be working under us, or other employees whom we hire for doing various services. It is always necessary that we always keep up an employment agreement with those people, because tomorrow when employees work, one thing that an employment agreement does, it provides a security not only to the company but also to the employees. And when an employee is secured, he would want to work more efficiently and more hardworkingly for a company. So employment agreement, not apart from that, an employment agreement also provides for the remuneration terms of the employee, the working hours of an employee, the reporting and management system, the structure of the work he'll be doing. And it also provides for other notice period confidentiality agreement, that he doesn't share the ideas of the company with other people. Notice period, it provides for that any person who wants to leave the company shall and must provide a period of time before leaving the company. Confidentiality is very necessary so that our idea doesn't, again, an employee doesn't go out and spreading our idea or of the enterprise. Moreover, it provides for remuneration. Major disputes, if we look out between the employee and a firm happens are for the remuneration itself, because an employee says that he should be have given an X amount of money. The company says no, Y amount is right for you. So it is necessary when we put up that. And apart from that is the role or the functioning he'll be doing in the company, and the person, the structure of reporting, whether it is going to be vertical, whether it's going to be horizontal. It is necessary that all these roles of an employee set forward so that tomorrow no legal complications come up between the company and the employee. Next is an independent contract agreement as well. As employees of there are employees of the company, at times what happens is we have to hire in third party people from outside, from whom we'll have to get certain contracts done or certain job work done. So it is necessary whenever such a contract is done, whenever such work is done from a third party individual, it is necessary we build up a independent contract agreement as well along with that person. Again, I say each and everything a company does is necessary to be done in writing, so that tomorrow any dispute which comes up, you have something to be held against or hold any person against. So whenever a contract is also done, it is necessary you put in the scope of the work to be done by the contractor, the project timelines, the payment terms, and what will be his roles and responsibilities of other parties in that. And also apart from that, the insurance obligation. Supposedly you're giving out a contract to a third person, he doesn't fulfill that or leaves it in between, it is necessary that we have an insurance or something as such where we do not go under loss, and we have a term and condition wherefore we can either go forward and complete that, or we can be compensated in such a way that it can be done through a third person individually afterwards, and a loss doesn't have to be suffered by the enterprise. So it is necessary that it contains the insurance part, or as they say nowadays, bank guarantee is given. So it is necessary all that we put up. Thus again a question is, bond signing allowed with employees? Bond signing is basically you're restricting an employee to work with you for certain period. No, they do not become laborers. An employee remains an employee. A white collar person remains a white collar, and blue collar remains a blue collar. But however, bond signing is when you're limiting an employee to certain period. Of course, supposedly you have an intellectual property which you do not want it to go outside the company, and you don't want it to be spread out and your idea be shared with someone else. The best what we can do is we can ask our employee not to spread it around. We do share an NDA, as I have told earlier. It is necessary we also get an NDA signed from an employee. And apart from that, we also get in his contract itself a non-competence agreement, that tomorrow, even if the employee leaves the company or the enterprise, he doesn't go about and creates a competitive firm with us, so that he tries to pull in our clients and tries to pull in our work. It is necessary that what we do is put in a non-disclosure and a non-competence clause in it. Bond instead of bond, the best we can do is a notice period is what can be done, because of course every person has a right to life and liberty, as it's a constitution right. So it is his liberty that he should not be restricted as such. But however bonds are done by the company, there's no harm in having a bond as such. Now we were coming to, yes, what happens is supposedly joint venture or partnership agreements. Whenever we form a joint venture with anyone or partnership with anyone, it is necessary we put forward the management structure in that agreement as to how will the affairs be managed by, and by what people will they be managed. It is necessary that any restrictive convenience we also be put forward in that. Supposedly the brand name, trademarks, everything we put up, how will they be used and how will they not be used. Parties' individual rights after the end of agreement. then exit strategy. Now, in a partnership firm or a joint venture company, there are people and partners who would want to partner in together, come together and form a firm. For joint venture, come together and form a venture. Supposedly tomorrow it is all going. You never know. The future it's full of contingencies. Supposedly it's going on the right track, but however it can get derailed at one point or the other. So when that happens, it is necessary, if one person wants to exit, it is necessary in that partnership agreement or joint venture agreement, we put in the clause of exit as well. We put in the clause for joining, we put in the clause for exit as well. Tomorrow a person wants to leave, that's right, you can leave, but what will be your scope and what will be your limited aspect on basis of which you will be allowed to leave, and what and all as a functioning you'll have to complete. It is necessary we put up that how and when can you do the, so that would be called an exit strategy. It is necessary an exit strategy always be put in a partnership contract or a joint venture contract. This is also necessary. Why? As in, because of course small businesses are not equipped with such resources and expertise. So whenever suppose two persons come together, one person might have certain expertise, one person might have certain resources. When they come together for a joint venture, so it becomes a complicated situation there. It is necessary to keep all these things in writing for that reason itself, so that the strategical person and the resourceful person work hand in hand, glove in glove, so that the company can go forward and prosper, as they say. Then of course, lease agreement. Tomorrow a company is working out of a rented property, a rented house, a rented space. They want the company to be run there for at least 2 years, 3 years, 4 years per se. It is necessary we form in a lease agreement. Without a lease agreement, what happens is we do not have in the terms and conditions of a lease the time period. No, I haven't shared any PPT, Mr. Tal. So my video is visible? Mr. Tiwari, is my video visible? Yes, okay, yeah. Yes, right. So whenever we take up any a place or an accommodation for any space for a work, it is necessary the lease agreement is always formed. Why? Because the lease agreement will provide for the time period of the lease. It will provide for the amount of rent that has to be paid out. It will provide for the functioning we can do at the place. It can also provide what and all duties we have towards a place and what and all rights we have it towards a place. It will also provide for the deposit, supposedly a security deposit that we'll have to provide in. It will provide for the structural changes we can do, and the structural changes we are allowed to keep and make, whether they have to be temporary or permanent. And apart from that, it also provides for a notice period as to leaving the place, whenever either we have to leave the place or the landlord or as they say the lessor asks us to vacate the premises. It is necessary all be put up in writing. A lease agreement is done tomorrow, so that any dispute towards that comes up, a company is not made to shift overnight from its place of business. Apart from that, what are the agreements that are necessary is intellectual property. As I said, ideas. So any startup has its idea. It is necessary we have an intellectual property agreement set out for that. I believe a session for intellectual property is there tomorrow as well. I wouldn't go in detail, but there are many. There is there are many cases which come up, legal cases which come up in relation to dispute of intellectual property. What happens is a person's trademark is being used by someone else at times. A person's design is being registered by someone else when it has already been registered earlier. So it is necessary an intellectual property agreement also comes up, which provides for all the secured ways, how can the idea be secured? And the intellectual property agreement has to be done so that it provides for any trademark, any patent, any design which has to be registered tomorrow. It is necessary a agreement or a contract or a proper document be drawn up for the same tomorrow. If any idea of ours is not uh, given heed to, or not taken up, or is used by someone else behind our back without giving any notice to us, so that that intellectual property can be secured, and it is necessary we get those registered. And tomorrow any legal complexity which comes up, that is dealt for before the tribunals which are there for it. I believe the session will be there tomorrow on that, so I wouldn't go much into that. Apart from that, there are various terms in a contracts and various terms in agreements which are used, as I also use void ab initio. So void ab initio would be something which is illegal from the very start. Void is illegal, ab initio is from the beginning. Then there are words like prima facie, that what a prima facie is from the very beginning or from the face of it, they say. There are many individual words. If there are any words which come up in your mind, you can always put up a question and ask in that. But for the agreements, I'll like to even state one thing. All those agreements which I've stated, so whether it be shareholders agreement, whether it be founders agreement, whether it be an employee agreement, whether it be a lease agreement, it is necessary that an alternative dispute resolution clause also be drawn up in major of the agreements wherever it is possible. Because whenever a dispute happens tomorrow, going into the legal complexities, of course, it's a costly affair, but it is necessary an ADR process is set up. Alternate dispute resolution mechanism is set up. Every contract, I say, should provide for that. Tomorrow, supposedly, the firm is having a dealing with the firm A is having a dealing with firm B. Firm A is based out in Mumbai. Firm B is based out in Delhi, per se. They are dealing with each other. It is necessary we put up any dispute tomorrow which happens will be done either through ADR, that is alternate dispute mechanism, which includes your mediation and arbitration and conciliation. So it is necessary an ADR agreement also be put forward. And apart from that, it is also necessary that the jurisdiction of the place where we want to do the litigation we also set up. However, it doesn't matter at times, but for at least for alternate dispute resolution, it can be set up where the major or the in between, or as we say, the mediation point can be set up where the mediation and the alternative or arbitration proceedings can be done. This is one of the major things that are necessary. And apart from that, any questions on that, then I'll go towards the legal aspects of disputes which happen and how the court procedures will be done. That any questions on agreements? Yes, Tarunji has asked to share a note on points we should take care. Tarunji, I'll
पुलकित जी आप म्यूट हो गए हैं, एक बार अनम्यूट कीजिए प्लीज.
अरे yes, I'm sorry. Yes, Tarun ji ने पूछा है कि if I can share a note on points we should take care of. So I'll share a PDF of those points, and so that it can be circulated to the participants later on.
Sure.
And then another question is how much role in these a founder has. Yes. So a founder is basically someone who forms the company from the very beginning. Founder plays the most important role in any formation, any of an enterprise. The founder has to put in his idea, his efforts, his time, his money. Founder puts in everything. So it is necessary the founder draws up all those agreements, the founder's agreement, the shareholders agreement, the lease, the employment, the contracts, each and everything. It is necessary for a founder to protect its right tomorrow. It is necessary he puts it up, because at the end of the day, the founder is the one who is putting up the company and setting up the company. Tomorrow, any dispute or I say anyone comes up to take up his company on his own name. So it's necessary everything comes up in black and white, and everything is signed, duly signed, and supposedly a contract is given. When we have investors, supposedly we are taking any investment from banking institutions, NBFCs or anywhere else. Whatever agreement we do, whatever contract or any document we hand over, it is necessary a copy be kept with us, and we also get a receiving of the same with us, so that it is not disputed that no, it was never received to us. Mr. Setia, if that answers, or there is something else you wanted to.
आई थिंक एक लास्ट क्वेश्चन ये जो है सर, मींस इट्स ऑल डन बाय एडवोकेट। आई थिंक ये जरूरी नहीं है एडवोकेट ही करे, बीइंग अ चार्टर्ड अकाउंटेंट, बीइंग अ प्रोफेशनल आप भी कर सकते हैं, प्रोवाइडेड कि आपके पास एडिक्वेट नॉलेज और एक्सपीरियंस होना चाहिए।
यस, बिल्कुल, मिस्टर तिवारी सेड इट राइटली। वो जरूरी नहीं है एक एडवोकेट करे। यूजुअली जो फॉर्मेशन का काम होता है वो एडवोकेट से ज्यादा एक सीए या सीएस ज्यादा करते हैं। द फॉर्मेशन ऑफ अ कंपनी, फर्म, पार्टनरशिप, एनीथिंग, वो एक सीए या सीएस ज्यादातर करते हैं। इनफैक्ट आई से कि मैंने मेरी खुद की एक एलएलपी फर्म है। इंस्टेड ऑफ गोइंग इट बाय सेल्फ, जो लीगल या सेक्रेटरियल कंप्लायंसेस है वो मैंने सीएस से ही करवाए हैं। सिर्फ अग्रीमेंट वगैरह मैंने खुद ड्रॉ किया था। हाँ, तो अग्रीमेंट्स के लिए हाँ, मैं जरूर कहूंगा कि एक आप एडवोकेट की हेल्प लीजिए। और पर फॉर्मेशन के लिए आप यू कैन डू इट ऑन योर सेल्फ, यू कैन डू इट थ्रू अ सीएस, यू कैन डू इट थ्रू अ सीए, because they can help you with the secretarial compliances and the other formation documents. For any legal terms, any documents to be drawn up, of course you need a legal counsel there, because there are various loopholes. बहुत सारे कमियां हम निकाल सकते हैं किसी चीज में, जो आपको एक एडवोकेट बता सकता है कि नहीं, ये नहीं होना चाहिए था, इस जगह ये नहीं, ऐसा नहीं आना चाहिए था। लूप होल्स काफी काफी रह जाते हैं। मैं छोटा सा एग्जांपल देता हूँ। मैं आपको एक शेयर होल्डिंग अग्रीमेंट में एग्जांपल दे देता हूँ। शेयर होल्डर्स अग्रीमेंट आपने बनाया, उसमें आपने शेयर तो फिक्स कर दिए कि 100 रुपीज के रहेंगे, each share will be of rupees 100, but however you haven't fixed up the extent of shareholding one person can hold, so it is necessary all those come up. तो वही छोटा छोटा लूप होल होता है। कई बार एक पर्सन कैन बाई द 100% शेयर होल्डिंग ऑफ कंपनी, and the founder can be kicked out of its own company. So it is necessary to get a legal help so that all your loopholes are covered in an agreement.
यस मनोज जी, बिल्कुल बिल्कुल शेयर किया जाएगा। एक पॉइंटर आप सबके साथ शेयर करेंगे, पुलकित जी हमारे साथ शेयर कर लेंगे, दैट विल बी शेयरिंग विद यू ऑल ओवर मेल। Any further question from the participants?
Bonds are legal with employees. Yes, so bond are legal. You are setting up a contract. आप उनके साथ कॉन्ट्रैक्ट कर रहे हो, हाँ, बट कल को अगर आप जाते हैं तो उसमें एक टर्म जरूर, एग्जिट स्ट्रैटेजी, एज आई सेड, इट इज नेसेसरी टू बी पुट अप कि सपोजली समवन वांट्स टू लीव अर्लियर, व्हाट आर द कंडीशंस अंडर व्हिच ही कैन लीव. Only under such and such conditions he can be allowed to leave.
So I think we don't have any further question. Pulkit ji, you want to share something else?
हाँ, मैं अब थोड़ा सा लीगल एस्पेक्ट के ऊपर जाऊंगा.
जी जी.
लीगल एस्पेक्ट्स इन द सेंस, जब कोई भी कंपनी एलएलपी फॉर्म होती है या उसके कोई भी डिस्प्यूट्स आते हैं, तो देयर आर वेरियस कोर्ट्स एंड ट्रिब्यूनल्स इन इंडिया व्हिच लुक इनटू दैट. For a partnership firm, any dispute that comes up, as I can say, there's no tribunal or court as such for dispute to be held. वहां पे हमें बहुत ज्यादा जरूरी है कि हम एडीआर का एक जरूर वो स्कोप रखें, एडीआर का एक जरूर क्लॉज रखें हमारे पार्टनरशिप अग्रीमेंट में. बिकॉज एनी डिस्प्यूट, एक्सक्यूज मी, any dispute in a partnership agreement comes up, any dispute in that comes up, it can only be dealt with at there's no tribunal as such for it. It can be dealt through alternate dispute resolution, which is helpful in two ways. One is it is cheaper. Second, you do not have to go to the courts every other day. In that, a third party mediator who is nominated by both the parties comes up together and does the work. And ADR not only for partnership, it is necessary कि company LLP उनके लिए भी हो. अब company LLP के लिए क्या है? Companies Act is there. Companies Act of 2013 is there for companies. It provides for various types of matters under section 242 and 243, 244. It provides for operation and mismanagement. कई बार ये company में क्या होता है कि there are certain works which are going on outside the purview of company and something which is against or not in benefit of the shareholders of the company. It is necessary to be stopped at this very instant. So tab what happens is section 242, which provides for operation mismanagement, or there are affairs in the company going on. Operation and mismanagement helps out to stop those affairs of the company. A case is filed before the NCLT जहां पे कोई भी ऑपरेशन या कोई भी मिसमैनेजमेंट हो रही है इन द अफेयर्स ऑफ द कंपनी कैन बी लुक्ड इनटू. उसके लिए फाइल करने के लिए इट इज नेसेसरी 10% शेयर होल्डिंग, a person having 10% shareholding or shareholders to the tune of 10% come together to file the case. If that is not that, we can apply in under section 244 जहां पे हम exemption ले सकते हैं कि नहीं हमारी मेरी 10% से कम है और वो भी जरूरी है. तो section 242, 244 provides for operation mismanagement to stop any mismanagement in the affairs of the company going on and any operation in the company going on. Supposedly someone transfers the share of one shareholder in its name without the consent of the other shareholder. That point, the operation mismanagement comes in. The Companies Act comes in. That's where we also step in. We as advocates step in. Then there is mismanagement in the affairs of the company going on. There have been transfers of land of the company, properties of the company, assets of the company are being transferred, are being sold without the consent of the shareholders. That again, through the operation and mismanagement, it was going to help each and every one of us. So it is always necessary. Anything that goes out, the company or the founders approach any person, just person whom they feel can help them out. Apart from that, operation and mismanagement is one thing. Another thing which is helpful for the partnership firms, for the companies and others is whenever we are doing any business dealing, we are offering our services or we are offering goods, we are offering any commodity, we offer it for a price, we offer it for something in return. जब हम किसी को कुछ बेचते हैं, कुछ देते हैं और उसका हम ऑफ कोर्स इट इज नेसेसरी कि हम उसका अग्रीमेंट या इनवॉइस या कुछ ना कुछ ड्रॉप करें कि दैट ऑन कंप्लीशन ऑफ सच एंड सच कॉन्ट्रैक्ट, ऑन कंप्लीशन ऑफ सच एंड सच सर्विस, ऑन प्रोवाइडिंग ऑफ सच एंड सच गुड्स, such and such amount is due from us, we raise an invoice. Kal ko if someone disputes that invoice, of course does not pay that invoice, that happens a lot again. So hamare paas what we have is we can go to the courts before three different places. One is the civil courts. The civil courts mein hum recovery ka dalte hain case, for we file a suit for recovery before the civil courts जहां पे हम कहेंगे x and y owes us money, तो उसने मुझे पैसे देने हैं, मैंने ये सर्विसेज प्रोवाइड की थी. अब यहाँ पे हमारे अग्रीमेंट्स का एक सर्विस वाले सर्विस प्रोडक्ट में काम आएगा. व्हेनेवर सर्विस इज ऑफर्ड, इट इज नेसेसरी हम एक सर्विस अग्रीमेंट जरूर ड्रॉ करें, कॉन्ट्रैक्ट अग्रीमेंट जरूर ड्रॉ करें। जैसे मैंने कहा कि बाहर से अगर हम कोई भी सर्विस अवेल करते हैं कॉन्ट्रैक्ट, क्यों, दैट इज आवर प्रूफ, वो हमारा प्रूफ है कि हमने वो सर्विसेज रेंडर की हैं, वो हमारा प्रूफ है कि हमारे बीच में ये कॉन्ट्रैक्ट हुआ था। और उसके बाद इनवॉइसेस भी जरूर हम लें और कोशिश होए कि एक्नॉलेज होए दूसरी साइड से, so that we have that acknowledgement as a proof to show that services were offered, invoice is raised, bill has not been, the invoice has not been in cash, or payment to that has not been paid. These, any document, it is necessary to file a case, because these documents help you, provide you with a strong legal footing. Without those documents, our case will stand weak. तो वन प्लेस वी कैन गो इज सिविल कोर्ट्स में, डिस्ट्रिक्ट कोर्ट जो कहते हैं, रिकवरी सूट हम डाल सकते हैं, पार्टनरशिप फर्म्स वहां जा सकती हैं। हाँ, अब पार्टनरशिप फर्म अगर वो रजिस्टर्ड है, it is set up in a partnership agreement is drawn, partnership is registered, partnership deed is drawn, that partnership deed is registered, only a registered partnership firm can file a case and a case can be filed against it. सिर्फ एक रजिस्टर्ड पार्टनरशिप फर्म के अगेंस्ट केस फाइल हो सकता है या फाइल वो कर सकती है। अगर पार्टनरशिप फर्म रजिस्टर्ड नहीं है तो वो सिविल सूट में केस नहीं फाइल कर पाएगी कोई भी केस चीज के लिए। सो हमेशा ये ध्यान रखें कि पार्टनरशिप फर्म बना रहे हैं तो रजिस्टर्ड जरूर कराइएगा। तो उस उधर क्या आता है कि एलएलपी जरूर आप और के काम आता है वो फॉर्मेशन में। आई थिंक सो द सीएनसीएस विल हेल्प यू मच कि एलएलपी में आपको उस चीजों से काफी राहत मिल जाती है। देन सिविल कोर्ट इज वन, द अदर इज एमएसएमई। आई वुड आल्सो सजेस्ट व्हेनेवर any new startup is formed, they do get themselves registered under the MSME Act. The MSME Act came in 2006, 2006 में ये एक्ट आया था, जिसमें काफी सारे हमारे इनफैक्ट गवर्नमेंट की तरफ से स्टार्टअप्स को तो बहुत सारे immense amount of benefits have been given, we cannot even imagine. And apart from startups getting benefits from the government, there have been many benefits which are given to an MSME. So MSMEs, an MSME registration I would suggest is always must. There are many there are various three classification of MSMEs: small, micro, small and medium. The classification is done on basis of an investment or on basis of a turnover. So it is necessary any company which is, or any firm, a sole proprietorship be, let it be a partnership, let it be a company, anyone and everyone can get registered under an MSME. So it is necessary, I would suggest, to get an MSME registered. Why? Because MSME, instead of going towards a legal course of civil suits, which is a time consuming process, under the MSME Act, there is procedure of conciliation and arbitration, which again is a less time consuming process and again is a less money investment process. वहां पे आपका टाइम भी बहुत खर्च होएगा और आपको पैसे भी बहुत कम खर्च होंगे। इन आर्बिट्रेशन एंड कंसिलिएशन, एज आई सेड अर्लियर, जब आप रिकवरी सूट डालते हैं, रिकवरी सूट की कोर्ट फी ही आपके अमाउंट के ऊपर परसेंटेज पे होती है। एमएसएमई में मैक्सिमम कोर्ट फी, मिनिमम कोर्ट फी 2500 से है और मैक्सिमम ऑल्सो इट इज ओनली जस्ट इन 0.01% ऑफ योर अमाउंट। तो एमएसएमई इज अ चीपर ऑल्टरनेटिव, so it is necessary to get it registered under MSME. Another is company codes. Companies के लिए क्या होता था, under Companies Act of 1956 there used to be, they used to approach for winding up of company. Supposedly I owe money to a company or I owe money from a company. What I would do is I would show my papers, put it up in a court, I'll file a winding up petition against the company that this company owes me money and it is not paying me my money. In view of that, this company should be wind up, which cannot pay my money. How can it run a business? As simple as that. But now what has happened, एक नया law आ गया है, it is called Insolvency and Bankruptcy Code. तो वाइंडिंग अप की जगह, और नई कंपनीज एक्ट 2013 के बाद जो भी कंपनी थ्रू कोर्ट वाइंड अप होती है वो इंसॉल्वेंसी एंड बैंक्रप्सी कोड के थ्रू होती है। उसमें हम केस फाइल करते हैं कि दिस कंपनी कैन नॉट ओwe me money, it be declared insolvent and let a third person resolution professional step in, run the company and try to provide a resolution for the company and revive the company. Whether it can be done by the same directors itself, yes. Under when we are registered under the MSME Act, Insolvency and Bankruptcy provides for resolution by the directors also, or the suspended directors or the founders as well. If it is not an MSME registered, the suspended directors or the founders of the company cannot revive a company. Again, there are at times cases where a startup is going well, but something happens, something financially, it makes the company really weak. Then in this cases, it also helps a company to show that I cannot give a money. Please, someone come in and help me revive the company. In those cases, there is IBC code, insolvency and bankruptcy code, and the resolution process under that really helps out a company. There are certain questions, we'll answer that first. For an okay, this is for Mr. Tiwari. I think he'll answer this afterwards, Mr. Manoj. Yes, any questions on legal aspects of recovery? Then I'll go for other legal aspects as well. Yeah, मैं बता ही देता हूँ पहले. Mr. Tiwari, should I explain first and then we'll take the questions together? Yes, should we register in LLP or MSME? Mr. Setia, these are two different things. LLP is a type of a corporation. Like a sole proprietorship is a concern formed by one person who is a sole proprietor who runs the business. Partnership firm is there, which is formed by two persons. As here, LLP is a incorporation which has the characteristics of both partnership and a company. MSME is different. MSME can, a sole proprietor can be an MSME, a partnership firm can be an MSME, an LLP can be an MSME, a company under the Companies Act can also be an MSME. MSME is a registration, is a class different. MSME is not a incorporation, it is a certificate which is given to us that you are classified as a micro industry or a small industry or a medium industry in a micro firm, a small firm or a macro firm in the whole industry in which you're dealing. MSME एक तरीके का एक पार्टनरशिप फर्म है जिसकी मान लीजिए सर्विसेज में टर्नओवर 10 करोड़ रुपीस है, तो वो एक एमएसएमई में रजिस्टर हो पाएगी 100 करोड़ रुपीस तक. वो भी अभी नई क्लासिफिकेशन आई थी अंडर द एमएसएमई एक्ट, उससे पहले काफी कम होता था. तो it is not, you can form an LLP, you can form a company, you can form a partnership, but all these can be registered under the MSME. Sir, a startup and MSME, you can register yourself as both. An MSME is, as Mr. Manoj has written, a body for formation and administration of rules and regulations of laws relating to that. Yes, Mr. Manoj, that is the act which provides for that. An MSME enterprise, there is MSME council as well, which governs it. But an MSME is an enterprise in itself. Supposedly, मैं एक एग्जांपल आपको देता हूँ. एक क्लोथिंग कंपनी है, देयर इज अ क्लोथिंग इंडस्ट्री है, गारमेंट की इंडस्ट्री ले लीजिए. गारमेंट ब्रांड एक्स, गारमेंट ब्रांड वाई, गारमेंट ब्रांड जेड. Garment brand X is a sole proprietorship. Garment brand Y is a partnership. Garment brand Z is a company. All these three are different. One is a sole proprietor, one is a partner, one is a company. But they are altogether what? They are a garment company. They are manufacturing garments. In same way, all three can get registered as an MSME and a startup. Startups and MSME both have better benefits in under the given by the government. So a startup is basically can be registered as as I said, all three modes of it can be registered as an MSME as well. MSME is a certificate which we get along with the startup. So both can go together. So I'll go for one more legal aspect, which is that whenever a company is, this is for companies or partnerships as well. Welcome. So what happens is any partnership firm or any company, whenever it is going, it's working, tomorrow we need to incorporate another firm with us. We need to merge another firm with us. We need to form a new company. It is necessary those agreements which are drawn provide for the formation as well of, as I said, the founders agreement. For founders agreement was that. Apart from that, that is formation agreement as well, which provides how the company would be formed. Supposedly a new addition is to be made, another firm is to be added, how it is to be done, through what process it has to be done, what will be the various complexities which have to be followed, legalities which have to be followed. Now for a partnership firm, what happens is we usually, in a partnership firm, partner can be any individual, it can be a partner, it can be a company. So there is no hitch in glitch as such, but you have to register the firm with the registrar of firms. The only requirement for a registering a partnership firm is getting registered with partnership firm. But when it comes to a company, supposedly two companies want to come together and form one company, there is, under the Companies Act, a procedure provided in it. The procedure is under section 230 232, which provides for merger and amalgamation. Two companies can come together and get merged with each other, or get amalgamated with each other. For that, what happens is we have to file a petition under section 230 232 before the National Company Law Tribunal, which is there all over India, having its benches all over India. A petition is filed there. You, as like any other case, we have a first motion petition in that, where in the initial we said that there is company A, there is company B, they want to merge their business, they want to merge their assets, they want to merge their liabilities, and a first motion notice is issued, whereby notice is given to all its shareholders, all its creditors, all its debtors, that such and such company wants to merge. It is given out to the public. If anyone has any objection, they can come forward and place their objection to that. And the notice is given to conduct their meetings. After the meetings is done, it is all given a thumbs up, it is given a okay. A second motion petition for that is filed, where the court gives a yes, all right, you can be formed together, you can be clubbed. Same is for demerger. Supposedly one company wants to form another wing, it wants to form another company of its. A company wants to get splitted into A and double A. So for that also a petition is filed for demerger under the same provisions of the Companies Act. So apart from that, I like to end it up on a short note itself, that whenever any startup is willing to go forward and start its journey, that's why it's called startup. So it's starting its journey, it is necessary. It goes up to fulfill all its compliances. It goes on to get everything recorded in writing. It draws up the agreements properly. It draws up all the necessary documents properly, takes help of all the professionals, because it is necessary, whether it be CA, CS, an advocate, it is necessary that whatever is going or put forward in the very start, your foundation, they say, it is necessary the foundation be strong. Only then the building would come up as a proper, with a will look beautiful, in fact. So it is always necessary, all those agreements, the foundation agreement, the shareholders agreement, the employees agreement, or any agreement, be drawn up in writing, be signed by all the necessary parties, as well provides for various terms if any dispute happens in any way, exit strategy, and all those other things. And it is also necessary, whenever any dispute happens in a company, never to hesitate approaching the legal course, because the courts are there for our help itself. And of course, we advocates are also there for your help. And any formation related queries, anything, it is always necessary to be put up in writing, no matter how. So all in all, any agreement of no matter what nature, any contract in what nature, be put up in writing, contains all the proper clauses. I'll share a brief, I'll share a gist of those in PDF, and all the loopholes we manage, due diligence be done so that no consequences are faced tomorrow at a later stage, and the vehicle of the startup runs on its proper journey without any puncture tire, as they say. Right. So any questions? We'll take up the questions as well. You can unmute and ask as well instead of typing. Mr. Sethi, again, I would say that it is majorly for a CA and CS to provide you with the compliances, the secretarial compliances. However, legal formalities are, as I said, all the clauses which you want in a franchisee model, especially. Franchisee models are run on basis of investment. How much investment is it necessary? What would be the role of the franchisee? What would be the royalty it would be paying out? What would be the model it will be working on? It is necessary these clauses be come up in a franchisee model of an franchisee model of enterprise. Please explain briefly of early exit for startups if they fail with their idea. Right. Early exit for startups. As I again said, a company or a partnership firm or anything which is formed, especially in startup, whenever we leave it in between, of course, if the idea fails, as in this Mr. Uh, Tarun is asking, if the idea fails, what happens is early exit, those agreements which we had drawn, whether it be the founders agreement, whether it be the shareholders agreement, or whether it be the association memorandum of association, articles of association, provides us the partnership agreement. It provides for the liabilities which we owe. So being a startup, being a enterprise formed fresh, it is necessary the clauses of early exit we put up in that. In early exit, we can provide for, supposedly we leave out of a situation, what will be the liability that will have to be contributed by the investors or will have to be contributed by the founder. This is one thing we'll have to put in it. Another would be what would be the scope of work that is left to be done and how can we try to do it by some other way. It is necessary a clause be put in for the shareholders benefit, for the investors benefit, that tomorrow they don't lose out on it, sticking out their duties towards an early exit. So early exit strategy and the proposals for that, I think so a CA would help you much better. As such, there is no if and but for a company if it fails out. As I said in the agreements, all the disputes and all the queries for that should be there. If a startup fails out tomorrow as well, anyone wants something out of it, it is necessary those clauses in agreement are put up so that they come into play tomorrow. So no liability, extra liability is drawn upon the founder or the investor.
So I think no further questions we have. All the questions have been covered. Yep. Any participants have any question? Please raise your hand. We are waiting for next 1 minute, else we'll conclude and sign off for today. Anybody have any question? If you want unmute, then we can just raise your hand. सुनील जी हैं आज सेशन में क्या? Okay, fine. So no further question. So Pulkit ji, thank you so much. And I was listening since the start, and very detailed you have addressed the importance of legal aspect which we look at for the startups. जैसा आपने इनिशियली बताया था कि जो फाउंडर्स एग्रीमेंट होता है वो बहुत ही ज़्यादा इम्पोर्टेंट होता है, क्योंकि हमने कई केसेस ऐसे देखे हैं कि फाउंडर को ही बाहर निकलना पड़ता है। कुछ ऐसे मैं पॉलिटिक्स बोलूं या कुछ चीजें ऐसी होती हैं कि जिसकी वजह से उसे अपना इंटरेस्ट सेव करना होता है। दैट इज व्हाई द लीगल एस्पेक्ट्स आर वेरी इंपॉर्टेंट। दे नीड टू अंडरस्टैंड व्हाट आर द पॉइंट्स, व्हाट आर द टेक्निकल इश्यूज, टेक्निकल पॉइंट दे नीड टू कंसीडर इन द एग्रीमेंट एट द टाइम ऑफ ड्राफ्टिंग। क्योंकि एक बार ड्राफ्टिंग हो गई, इन्वेस्टर्स के साथ शेयर हो गया, प्रमोटर्स के साथ आपस में साइन हो गए, तो वो हमें बाद में कुछ अगर इशू भी होता है तो हमें सेव करता है। जो फाउंडर है उनको सेव करता है, उनके राइट्स को सेव करता है। तो बहुत ही इंपॉर्टेंट होता है फाउंडर एग्रीमेंट। शेयर होल्डर्स एग्रीमेंट्स अगेन वन ऑफ द वेरी इंपॉर्टेंट एस्पेक्ट व्हिच यू हैव कवर्ड इन द टुडे सेशन। बिसाइड्स जो और भी एग्रीमेंट्स नॉर्मल कोर्स ऑफ बिजनेस में होते हैं, उसमें भी इंपॉर्टेंट ये होता है कि कभी अगर आपके साइड से कोई चूक हो जाती है या कोई आर्बिट्रेशन में केस जाता है, तो उस टाइम पे आपका जो एग्रीमेंट है, जो कॉन्ट्रैक्ट है, उसे बहुत ही माइन्यूटली, बहुत ही डिटेल्ड चेक किया जाता है और उसके लूफोल्स को यूज किया जाता है। सो जैसा आप पुलकित जी बता रहे थे कि लूफोल्स को हमें कैसे पकड़ना है, कैसे पॉइंट आउट करना है, किन लूफोल्स को हमें डालना है, जो कि लॉन्ग रन में हमारे अगर एडवर्स सिचुएशन होती है, सो एट दैट टाइम वी कैन टेक द सेफर साइड ऑन द बेसिस ऑफ दैट लूफोल्स व्हिच वी हैव पुट in the initial agreement. So it was really very important aspects which you have covered in the today's session. So we are really thankful to you, Pulkit ji, for giving your precious time with all the participants who have joined over the Zoom and YouTube, live YouTube. And thank you all the participants for joining us today. Yes, Manoj ji, we are going to share the PPT with all the participants who have registered. You will get over mail. And thank you so much, Tarun ji, for organizing all this, arranging all the faculty. I would say very experienced faculty you have arranged for the session. And thank you so much once again, Pulkit ji, for joining us today, and look forward to have many more sessions at GEPA Global with you. Thank you. Thank you, everybody.
Thank you so much.
On behalf of GEPA Global, we are really thankful to each and everyone who has joined here and over YouTube. Thank you, everyone. So now we are signing off for today. Thank you.
Thank you.